Maduro chained and dragged to court. Foreign president charged with drugs. Trump vows full wrath of justice. But what do the laws actually say? As Maduro appears before New York City court.
History repeats itself, quite indeed. In this case, the United States of America, this age-old adage keeps coming true. Hello and welcome. You're watching NewsX Explained. This is not the first time that the US has gone into Latin America and captured its leader for drug trafficking. Nearly 36 years ago, the US invaded Panama and arrested its ruler Manuel Noriega under the operation called Just Cause. Now, under President Donald Trump, US forces have captured Venezuelan President Nicolas Maduro and his wife and have launched a large-scale strike on the country, including its military bases under Operation Absolute Resolve. In 1989, the US government invoked self-defense as a legal justification for its invasion of Panama. But what is the justification today? Is the US allowed to enter another country and capture its head of government? Can Maduro's trial in the US hold water, really? Let's understand. Let's dive into the arguments given in these 3 points. What does the international law state? What does the United Nations state? And what is the US government saying? According to international law, the US does not hold the power to capture the working head of any country. Sovereign immunity in international law is a legal doctrine that protects a sovereign state from being sued in foreign courts without its consent. This principle is rooted in the notions of sovereign equality and non-interference. According to the United Nations, Trump's capture of Maduro is a clear violation of the UN Charter signed in October 1945. A central provision of the agreement is Article 2.4, which states that states must refrain from using military force against other countries. Let me quote what this UN Charter article actually says. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. Jeffrey Robertson KC, former president of the UN War Crimes Court in Sierra Leone, has said, and I'm quoting here, America is in breach of United Nations Charter. It has committed the crime of aggression, which the court in Nuremberg described as the supreme crime. It's the worst crime of all. The only two expected exceptions to this rule is number one, the UN Security Council approval, and the second is self-defense. It is evident that the UNSC approval was not something that Trump sought before taking Maduro. Moreover, the self-defense narrative is indirectly being used by the US authorities. It is said that it is a part of a military operation that ensured law enforcement. US officials have accused Maduro of backing drug cartels that Washington has designated as terrorist groups and claim that these organizations were responsible for thousands of US deaths tied to illegal drug use. The US Justice Department had already indicted Maduro during President Donald Trump's first term. A superseding indictment unsealed on the 3rd of January adds fresh charges of narco-terrorism and cocaine importation conspiracy. On your screens, you can see the South American leader being escorted by heavily armed law enforcement officers to a courthouse in New York, having been transported by helicopter and armored cars earlier. Now, what are the charges against Maduro? Maduro is being charged alongside his wife, his son, and 3 others. Maduro is indicted on 4 counts. Number 1 is narco-terrorism conspiracy. The second is cocaine importation conspiracy. The third is possession of machine guns and destructive devices. And the fourth is the conspiracy to possess machine guns and destructive devices. Maduro is facing the same charges as an earlier indictment brought against him in Manhattan Federal Court in 2020 during Trump's first presidency. But the question is, will Maduro's trial hold water in the courts? Under the US Constitution, Congress has the power to declare war while the President acts as Commander-in-Chief. However, Secretary of State Marco Rubio has confirmed that the Congress was not notified before the Venezuelan operation. In addition to lack of congressional approval, the critics say that drug trafficking does not meet the international legal threshold of an armed conflict that would justify cross-border military force. While the US authorities could play with the self-defense narrative and wrath of the American justice, President Trump did not maintain the story. At a press conference to address the strikes, the US president accused Caracas of stealing US oil interests, following it by saying that the US will be running the country for some time. Listen in.
Going to run the country until such time as we can do a safe, proper, and judicious transition. So we don't want to be involved with having somebody else get in, and we have the same situation that we had for the last long period of years. So we are going to run the country until such time as we can do a safe, proper, and judicious.
In the court, the United States is going to argue vigorously that drug trafficking is a scourge and it's killing many people. But a lot of international law experts have been looking at this, and there wasn't even clear evidence that those drugs were trafficked from Venezuela, let alone that they were governed by Maduro in any sense. One of the legal pillars that ensures that Maduro's trial would certainly happen is a 1989 Justice Department opinion authored by then Assistant Attorney General Bill Barr. In the memo, Barr argued that even if a foreign leader is seized or brought to the United States in a way that violates international law, that does not automatically invalidate the criminal case against them once they're before a US court. This reasoning, rooted in earlier Supreme Court rulings, essentially separates the legality of the arrest from the court's power to try the accused, meaning the prosecution can proceed regardless of how the defendant arrived on US soil. When it comes to congressional authorization, there have been past instances where presidents deployed US forces and ordered the use of military force without the Congress authorizing the same. For example, President George H.W. Bush ordered the US troops into Panama in 1989 to protect US citizens and bring former President Noriega to justice. President Clinton ordered the deployment of US forces to Haiti in 1994 and US participation in NATO bombing campaigns in Bosnia and Kosovo in 1995 and 1999. President Barack Obama ordered the US military to participate in the bombing campaign of Libya in 2011. So as long as Trump's administration can justify that deploying US forces and extraditing Maduro was necessary to protect American citizens or interests, it's apparently fine. Under international law, the use of force inside another country may be lawful if it is carried out with the valid consent of that state's legitimate government. If the United States maintains that it recognizes an alternative Venezuelan authority as the country's lawful government and that authority has formally requested US assistance, then Washington can argue that the US actions are not intervention but defensive support provided at the invitation of the sovereign government. Let's listen in to what Marco Rubio said in this matter.
Well, I don't have much to add to what you've heard now, other than the following points. Nicolas Maduro was indicted in 2020 in the United States. He is not the legitimate president of Venezuela. That's not just us saying it. The first Trump administration, the Biden administration, the second Trump administration, none of those three recognized him. He's not recognized by the European Union and multiple countries around the world. He is a fugitive of American justice.
The crux of this argument is that the 2024 elections in Venezuela, it was held to choose a president for a 6-year term beginning on 10th January 2025. The incumbent Nicolas Maduro ran for a third consecutive term, while former diplomat Edmundo Gonzalez Urrutia represented the Unitary Platform, the main opposition political alliance after the Venezuelan government barred leading candidate Maria Corina Machado from participating. International monitors, including the US, called the elections neither free nor fair, citing the Maduro administration having controlled most institutions and repressed the political opposition before and during the election. This could be the strongest legal argument of Trump's administration. In Panama, in the Noriega case, the US had already recognized another leader as Panama's legitimate president. With Venezuela, Washington does not formally recognize any alternative government, even though it calls Maduro the de facto but illegal ruler. Whether courts will apply the same logic to Maduro, whom the US recognized for years before withdrawing recognition in 2019, remains an open question. Nicolas Maduro's case risks setting a complex precedent in geopolitics and international law. It blurs the line between legitimate law enforcement action and unilateral regime removal, raising questions about whether powerful states may now feel emboldened to physically seize foreign leaders they accuse of wrongdoing, even without host state consent or UN approval. Supporters might argue that such actions close impunity gaps when formal diplomacy fails. Critics, however, warn that the move could weaken long-standing norms on sovereignty, non-intervention and due process, potentially opening the door for similar actions elsewhere. Conflicts such as China-Taiwan, the Russia-Ukraine war and the Israel-Palestine conflict could escalate. As of now, Maduro's case is being heard. However, time will tell what the law holds and how the law will unfold. With that,
Maduro chained and dragged to court. Foreign president charged with drugs. Trump vows full wrath of justice. But what do the laws actually say? As Maduro appears before New York City court.